Good. I call John Naylor.
Thank you, Mr. Speaker, and can I just say it's been wonderful to hear such widespread support across the House this evening for this bill. And I guess the reason why people have been so supportive of it is because at the heart of what this bill is trying to achieve is to keep vulnerable children safe. I think we can all agree on that. I think we'd all agree that that is a very good thing for us to be doing. And so, for that reason alone, I guess is the main reason why the Minister has chosen to put this through the Social Services Committee. I've heard a bit of disquiet around people sort of concerned that perhaps it should have gone to the Justice and Electoral Committee or the Law and Order Select Committees, and I can see the rationale as to what's drawn people to that way of thinking. But actually, when you consider that at the heart of this bill is protecting vulnerable children, that's exactly what we're about in the Social Services Select Committee, and I'm sure that committee will do an outstanding job of looking at the benefits of such a bill coming into law, and be able to sort of weigh up those justice issues. There's a little bit of crossover between those committees anyway, and so I'm sure that people will bring their expertise from the Justice and Electoral and the Law and Order Select Committees into the Social Services Committee to be able to assess this bill as it takes its passage through the Parliament. I think as I said, the great thing about this is it's about looking after potential victims, perhaps people who have yet to suffer abuse, but it also looks to protect past victims from being abused again from people who may have offended against them. In a bill like this, and in putting together legislation like this, it is in fact a balancing act. The balancing act between the personal freedoms of the offenders and also the safety of victims and potential victims. I think I've always been one who's believed in the fact that people can be or should be given the opportunity to be rehabilitated, to be able to come to a place where they perhaps can be reformed, and perhaps where they would no longer offend and no longer be tempted to offend. I think this is something that can happen. But at the same time, we should not just therefore presume that because somebody has shown some level of contrition that they are not at risk of offending again. And so for the sake of, as I say, those victims and potential victims, we need to put some protections in place. Now, this is, of course, a private register, and the reason for this is that it's not always benefit for information like this to be sitting out there in the public domain. Now, I know I'm sure we will get submissions come to the Select Committee from people saying, why don't you just publish a public register so we can all know who these people are? And Mr. Speaker, I think that's not the answer, because it can lead to sort of vigilante type behaviour. It can lead even to the victimisation from offenders who perhaps have been rehabilitated, who are trying to make the best of living a good life again after having made some bad choices. And so making this a public register is not the right thing to do. And it's therefore important that we do remember that and ensure that we keep the parameters of the privacy of this intact. Now, this is also not a new concept. I remember sort of close to 20 years ago sitting around in a staff room at Child, Youth and Family and people talking about whether or not a register like this would actually be helpful. And I think when you're looking at placing vulnerable children with families, this type of information would be good for Child, Youth and Family to know, particularly if they're looking to make a placement with a kin caregiver or someone within the whānau. Having access to this information via the police might be particularly useful to know, because the last thing you'll want to do is place a young person who come into the custody of Child, Youth and Family into the care of somebody who was a known sex offender, perhaps now not under any particular ongoing contact with the justice system. And it might be historical, but you still wouldn't want to take the risk of placing a child with them. So it's appropriate that people within Child, Youth and Family would have access to this information. And I think it's really important to understand that it's the police and the corrections that are going to have direct access to this information, and that they will have an ability to share it with authorised people within the Ministry of Social Development and the Housing New Zealand Corporation. Now, there's been a little bit of suggestion that there's some concern about if that information got shared any further, and I think it's important to understand that police or corrections and a third party, where it is deemed necessary to protect a child or a child is at risk, may then disclose this information to a third party. So it's not just that the police or corrections have an ability just to share this with absolutely anybody, but for example, if a parent of a child or a parent of some children was moving in with a new partner and that person was on this register, it might be appropriate for that parent to know that because it might not be something that they know about that person. So there will be some parameters around how and when this information could be shared, and it doesn't mean that it is then becoming a de facto public register. It still will be a private register limited to those people who are authorised to view it, who will have some discretion if they deem it as appropriate to keep a child safe from harm, to be able to disclose that to a third party if that was appropriate. Now, at the moment, offenders can disappear back into communities when they finish a sentence. If they've got to the end of any protection orders or any ongoing parole, it's appropriate that we want the authorities to be able to continue to keep track of them. What it does is that for those people who know the offenders, who know their patterns of behaviour, who know the things that are most likely to lead them into reoffending or impact on triggers that might lead them to reoffending, will then be able to assess that living arrangement that somebody's moving into. They'll be able to look and say, actually, that's not a good idea, and perhaps at that point provide some level of intervention. It also means that we'll be able to, I guess, ensure that where those offenders are perhaps tempted to reoffend, the knowledge that there is somebody who's keeping a track of them will act also as a deterrent for that. So the fact that even though they're not actually having to, they're not being punished, they're not having to still perform some sort of sentence, they're not necessarily under ongoing monitoring, but there is at least something in place which sort of says that actually someone's keeping an eye on us. Someone's keeping an eye on me to make sure that I am behaving, to make sure that I'm not reoffending. And you know what? If they really are fully reformed, if they really have been fully rehabilitated, then those people will not have anything to be afraid of, because that information will not be shared with anybody else. They will be able to continue living a normal life, but our communities can continue to operate in a way that is, at least in some way, better protected than they are now. It's not onerous for those people who are in this situation to have to report in once a year the information that is required to be on the register. And so, Mr. Speaker, it's a good piece of legislation. It achieves, hopefully, good outcomes. I'm looking forward to the select committee process where we can perhaps iron out any of the kinks that might need to be ironed out in it, where we can fully debate that trade-off between people's right to go about their business and personal freedoms, but also that we can balance the needs of our vulnerable children in our society. Thank you.
The next call is a split call. Jan